All right, so we're starting a new section in the book. Um, Over on page 428, you can see it's entitled Constitutional Limits on Judicial Remedies Against States. So we've been covering for a number of weeks now the powers of Congress under Article 1, Section 8. We are then going to cover, starting next week, additional powers of Congress that come from the 14th Amendment, one of the important post Civil War amendments that protects individual rights, things like due process and equal protection against violations from the states. But Congress will be given a specific power in the 14th Amendment to enforce the terms of the 14th Amendment. And the 13th, 14th, and 15th Amendment, the Civil War amendments, are the first time that Congress is given additional powers since the original Constitution, and those powers mostly are laid out in Article 1, Section 8. So, why are we taking this week to interrupt that study of Congress's powers? It's because through studying this concept of sovereign immunity, we will see an importance in distinguishing those types of powers that Congress is using. And it's not going to be crystal clear just yet why that is, but there is a reason for the way that we're sequencing things. Now, the study of sovereign immunity in the 11th Amendment can be very uh, detailed, very difficult. I'm going to do my best to lay things out as simply as possible. So the goal here is not to learn all of the intricacies of sovereign immunity or the 11th Amendment, but just to get a big picture to understand the basics of what is meant by state sovereign immunity and just the outer contours of some of these doctrines here. So, where should we start? Let's start with the text of the Constitution, and keeping with the theme of taking a break from looking at Congress's powers, we're going to go back to Article 3, which is the article that we started out with. We started out by looking at the powers of the federal courts. We started out by looking more specifically at the justiciability doctrines and what counted as a case or a controversy. Well, let's recall that particular text, the part of Article 3 that sets out the different headings of jurisdiction. So the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. So there's the federal question jurisdiction. Then a little later we have, just skipping over the red part for a minute, the judicial power shall extend to all controversies between citizens of different states. So there's the diversity jurisdiction. Notice the part in red. The judicial power shall extend to controversies between a state and citizens of another state. So what does that mean? If you look at modern versions of the Constitution, this part will usually be highlighted with a footnote that says something like abrogated by the 11th Amendment. So what does the 11th Amendment say? Let's read the text of the 11th Amendment, the very first amendment adopted after the Bill of Rights. It says, "The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state or citizens or subjects of any foreign state." So how did the 11th Amendment come to be? If you look at the language, it starts out exactly the same as Article 3, the judicial power of the United States. So if Article 3, Section 2 lists the jurisdictional headings, then the 11th Amendment, one could interpret it as simply removing one of the headings or explaining how those headings should not be interpreted. So what happened between the adoption of the original Constitution and the adoption of the 11th Amendment? So the book gives a very, very brief summary on page 428. Primarily what happened was this 1793 case, Chisholm versus Georgia. In that case, the Supreme Court allowed an individual, a private citizen of South Carolina, to sue the state of Georgia in the Supreme Court. This was a case where a citizen had provided Georgia some goods for the Revolutionary War. I believe the individual had provided some supplies for the soldiers, for one of the Georgia troops, and that person then died, and his estate is now seeking the debt be paid from the state of Georgia. So it's a simple contract claim. It's a simple debt claim, and the state of Georgia argued that as a sovereign, the state should be immune from suit. That no state should be able to be sued without its consent. This had long been a rule in the English common law, according to this argument, that came with the famous phrasing, the king can do no wrong. So the idea behind sovereign immunity is that the sovereign should not be able to be sued in its own courts or with the king in his own courts, because it's the sovereign that sets up the government. The sovereign is the one that draws all the rules up. And unless the sovereign consents to being sued in the very court that the sovereign created, then the sovereign can't be sued. So that was the idea behind sovereign immunity. And of course, one of the questions that arises here is, so what role does the concept of sovereignty play in a system like the United States, where there isn't just one level of government, but there's two, and especially when sovereignty, since the time of John Marshall, has been well explained as being in the people. So it's not even as though one entity in the government has sovereignty. The court tells us that sovereignty lies in the people. So is sovereignty even a valid concept? Well, the Supreme Court decided that it wasn't in Chisholm versus Georgia, and then the 11th Amendment gets adopted. And it's well understood that the goal of the 11th Amendment was to overturn Chisholm versus Georgia. The question that the court never has seemed to clarify with any degree of widespread agreement is, so just how much of Chisholm versus Georgia was the 11th Amendment designed to overturn? Was it only designed to overturn debt cases brought by out-of-state citizens against a state and federal court? And there's very good historical evidence to suggest that yes, that is what this was intended to be limited to. But in a very famous and important case decided in 1890, and this is also listed on page 428, called Hans versus Louisiana, the Supreme Court held that, so what happened in Hans? So in Hans, a Louisiana citizen was issued a state bond, and then the state did not want to make good on those bonds. The state didn't want to pay the bonds. So the Louisiana citizen sued Louisiana in federal court, claiming a violation of the Contracts Clause of the Constitution. And if you look at the 11th Amendment doesn't seem to prohibit that sort of suit. It says the judicial power shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States. So this does, so far, it looks like this is, like Hans's suit is a suit commenced or prosecuted against one of the United States. But then the 11th Amendment says by citizens of another state, or citizens or subject of a foreign state. But Hans was not a citizen of another state or a citizen of a foreign state. He was a citizen of Louisiana. So by its terms, the 11th Amendment should not have prohibited Hans's suit. But the Supreme Court holds that the 11th Amendment doesn't really mean what it says. The Supreme Court holds that the 11th Amendment is a general recognition of sovereign immunity, a sovereign immunity that predated the Constitution and that the states did not give up in the document of the Constitution. And so the 11th Amendment is really just a reminder of sovereignty. And remember, in the 10th Amendment commandeering cases that we just finished reading, the majority that likes the commandeering doctrine says something similar about the 10th Amendment, that the 10th Amendment is really just a reminder of state sovereignty. It doesn't by its terms do anything, but the spirit of it does a lot of work in those commandeering cases. And that seems to be what the court in Hans versus Louisiana was saying, and it really is the doctrine of the modern court as well. But always in very split 5-4 decisions. These 11th Amendment cases are notorious for having very, very fractured opinions. They've never been decided by more, these contentious cases have never been decided by more than 5-4 opinions. All right, so, and we'll see some of those very contentious cases in the next two classes on Tuesday and Wednesday. All right, so bottom line, the 11th Amendment stands for the proposition that a state cannot be sued in federal court, right, by an individual, whether an individual from out of state or from in state. But there are ways around the 11th Amendment. One way, the state can waive its own immunity. Right? If the state expressly says in statute or by a state statute, or if a state in court, in federal court, says we consent to being sued, then the Supreme Court has held that waiver must be express, but then the court can hear the case. The federal court can hear the case. Or, and we just finished looking at the very last class at the Congress's spending power. One of the things that Congress can demand of the states is that they allow themselves to be sued in federal court. So Congress could say, do you want this highway money? If you want this highway money, then you consent to be sued in federal court if someone accuses you of misusing this highway money. So that would be another way where the state could, through its actions of accepting federal funds, waive its sovereign immunity. We're not going to look at any cases dealing with either of those issues, at least not where that's the main point of the case. What we are going to be focusing on today is the second method of waiver, which is suits against officials. So I said the basic principle of the 11th Amendment is that states can't be sued. And we have to take that very narrowly, that states can't be sued by name. And it's states, state departments, or state entities can't be sued. But the court will say in this famous case from the early 20th century, 1908 Ex parte Young, that a suit against a state official can proceed without violating the 11th Amendment. And so we want to look at the intricacies of that in just a moment. So we'll see the court invoke Young, and then we will see the court reject applications of Young. So there are some exceptions to Young. And then the issue that we'll be looking at tomorrow and the next day, which is another way around the 11th Amendment, congressional abrogation of immunity. And this is where it will be very important to understand the basis of the federal law, whether it's a congressional statute that comes from Article 1, Section 8, or whether it's a congressional statute that comes from the 14th Amendment powers that Congress has. All right, so let's look at that second exception. So again, general rule, states cannot be sued by individuals in federal court against their will. One way around it is to sue a state official, not the state by name. So Young, here's the basic rule of Young, Ex parte Young. A federal court of equity may enjoin a state officer who is threatening to enforce an unconstitutional state act. So Young involved the Attorney General who was threatening to enforce a state statute against a railroad company. The railroad company said, this statute, which was a price control statute, the statute that you're threatening to enforce against us, we think is unconstitutional, violates federal law, and therefore the railroad company filed a suit in federal court to enjoin the state attorney general from enforcing the statute, the state statute. Right. The attorney general said, but the 11th Amendment precedent says that states can't be sued in federal court against their will. And when you sue me, the attorney general, you're in effect suing the state. And the court said, no. The court said that's not the case. Why is that not the case? Because the court said when an individual officer of a state attempts to enforce an unconstitutional act, that action of enforcement is not the act of the state in its sovereign capacity. I'll break down each of these points in just a minute. So, because the state is not acting in its sovereign capacity, it therefore has no immunity to impart to its officer. And therefore, when the officer acts in enforcing this unconstitutional state statute, the court tells us we can simply view it as an illegal act by an individual. So what do those 3 points mean? So first point, the enforcement of an unconstitutional act is not the act of the state in its sovereign capacity. So suppose that a police officer tries to arrest someone for passing out leaflets on the sidewalk, and that person has a First Amendment right to pass out leaflets. So if, let's say, the officer thinks he's enforcing a no trespass statute, but it turns out that it's unconstitutional to apply a no trespass statute to someone exercising his or her First Amendment rights. So the court tells us to think about that officer arresting the person passing out leaflets as not actually being an officer of the state at the point when he acts unconstitutionally. So for purposes here, we should view the person as simply a random man dressed in a uniform handcuffing a person without any state authority whatsoever. And if we view it that way, then we can understand why the person whose constitutional rights were violated can sue that individual in federal court for an illegal action. The court says if we think about it that way, then the state's sovereign capacity is not implicated at all. Right? It's only when the officer acts according to valid constitutional state statutes that the state officer is clothed with the sovereign immunity of the state itself. Now, the court recognizes in future cases that this is a fiction that the court creates just to allow suits that otherwise would be prohibited by the 11th Amendment, but it's a fiction that the court has always maintained. Right? So let's look at how the court applies this more concretely in the cases that we have here, namely Edelman versus Jordan and then the Pennhurst case. Now, in both of these cases, the court will rule against ex parte Young being a valid exception given the facts of the case. So let's make sure that we understand why. So the general rule, no suits by private individuals against states in federal court. The exception, you can sue a state officer for injunctive relief in federal court, but now we're going to have exceptions to the exception. So let's look at the first case we have, Edelman versus Jordan. So in Edelman, Illinois was administering a federal aid program to the aged, blind, and disabled, and the claim was that Illinois was maladministering the law, that they were processing applications late. And by processing applications late, people who should have been getting this federal aid were delayed in getting the aid because the application was processed late, and the statute required that the states who received this money process applications in a certain amount of time. So a federal court found that, yes, the claim had merit to it. Illinois was not doing what it should have been doing under this federal statute. And two remedies were issued by the federal court here, bottom of page 430. One remedy that was issued was that state officials were enjoined from continuing the maladministration. So the court told the state officials who were sued, look, stop violating the law from here on out. Anytime you get a new application, make sure you process it in the requisite amount of time. So that's one remedy that the federal court issued. A second remedy was the federal court issued a restitution order for the wrongly withheld benefits. So they essentially said the prospective relief is the injunction, but we're also going to award retrospective relief. We're going to say that all of the money that people missed out on because of Illinois' delay in processing applications, the state was going to have to pay back. Or the ruling was against the officers, but as the court tells us, this was tantamount to a ruling against the state itself. So page 430, the court first starts out by going through that history that I just explained, where we go from 1793 Chisholm versus Georgia the state of Georgia can be sued against its will. We go to the 11th Amendment, which undoes that holding from 1793, and then the court goes through Hans, where the 11th Amendment gets an expansive interpretation. But then we have this rule of Ex parte Young, which the court talks about on page 431. So this is a suit against the individual officers of the state who are administering this program. So under Young, shouldn't this remedy be just fine? And yes and no. The court tells us that the first remedy here, the injunction against state officials from continuing the maladministration, is a valid remedy against state officers under Young. But the second remedy here, the restitution for the wrongly withheld benefits, is not a valid way to enforce the Young exception. So the court here holds that Young does not permit retroactive monetary remedies. So page 431, the court calls this an accrued monetary liability which must be met from the general revenues of the state. So if you think back to the Chisholm versus Georgia, the 11th Amendment, one of the things that was really objected to with respect to that 1793 decision was that the states would be liable for monetary damages against their will. And one important aspect of sovereignty that the court has constantly talked about, is this ability for states to be able to manage their finances without outside interference from the federal government. And we can see that that idea coming up in the spending clause decisions that we just looked at, right? The state, if the federal government is going to impose obligations on states for accepting federal money, those obligations better be very clear so that the state can plan its budgeting without these unexpected issues arising, right? So one aspect of state sovereignty that the court likes to protect is this aspect with respect to its finances and its budget, right? So here, again, under Young, the prospective injunctive relief, the order to administer this federal program in the correct way in the future, that is fine. But the order that would have given the parties here, the plaintiffs, back pay was not okay. Right? The court further explains this. The court explains that the Young case emphasized that the remedy was against the state officer in his personal capacity, right? As I explained to you, Young was operating under the fiction that when state officers violate federal law, they're not actually acting as state officers at that point. But the court points out here that a monetary award to remedy past conduct, even if it's categorized as equitable, and the district court had not called this a legal damages remedy, the district court called this an equitable restitution remedy. The court says that even if you categorize this as equitable, it still is going to be an award against the state. This money is still going to come out of the state coffers. Right? Now, one response was, but sometimes injunctive relief actually has causes monetary harm to the state itself. So if you look in the middle of page 432, you can see reference to some of the there's a discussion of some of the racial discrimination cases, and those get discussed, I think, in both of the cases. But the idea here is that, let's say that a state is discriminating in schooling, and one of the remedies is, it's quite possible that the only way to remedy discrimination in schooling is to have to build a new school, and therefore the order is against the superintendent or the state chief officer of schools throughout the state, and the order is you must stop discriminating in the future against African American children. And maybe the only way for the state to actually accomplish that, for the state officer to actually accomplish that, is for the state to expend a lot of money. But the court calls that merely that might be cost, but that cost is merely ancillary to the injunctive relief, the underlying injunctive relief. So the court here makes this bright line distinction between relief that is prospective in nature, that's fine under Ex parte Young, but relief that is retroactive, a retroactive monetary order, that is not okay under Young, because that is essentially tantamount to an order against the state itself to pay out money. Right. Just going to point out a couple of other interesting things about the 11th Amendment on page 433. Right, the court points out that the 11th Amendment acts as a jurisdictional bar. So just as we looked at the justiciability doctrines as jurisdictional bars to the federal courts hearing cases, the court tells us that the 11th Amendment is also a jurisdictional bar. What's odd about this, however, is that, as I mentioned, one of the ways around the 11th Amendment was waiver. Right? The state can waive its sovereign immunity. The state can have the case heard in federal court if it wanted to. So Illinois, if it wanted to, could have accepted the jurisdiction for this equitable this equitable monetary award. Why is that odd? That's odd because we usually consider jurisdictional bars to be unwaivable, right? Think back to issues of standing or ripeness or mootness. Parties could not overcome those bars even if both parties wanted the federal court to hear the case, right? So this is an odd jurisdictional bar in that it can be waived by the states. All right. So the discussion, now I now see it, the discussion of equitable prospective injunctive relief, sometimes having very large impacts on the state's finances, on the state treasury, comes in Justice Douglas's dissenting opinion over on page 434. Right. And Justice Douglas tries to make the point that we should view this particular instance as a state waiving its sovereign immunity. He points out at the bottom of page 434, where a state has consented to join a federal-state cooperative project, it is realistic to conclude that the state has agreed to assume its obligations under that legislation. So in other words, the fact that the state agreed to this aged, blind, and disabled program, this type of welfare program, that the state should expect that if it misadministers or maladministers this program, it might be sued in federal court. But as I mentioned in the first slide, the waivers the Supreme Court has held must be crystal clear. It's an exceptionally clear statement requirement. Okay. So the next case on page 435, Pennhurst. So the question here is, can a federal court apply the Young exception? Remember, the Young exception, a state officer who is acting illegally can be sued for prospective injunctive relief. Can the state apply the Young exception when the basis for the injunction is in state law? So this would be, so imagine a previous case, but instead of the state officers being accused of violating a congressional statute, the state officers are being accused of violating a state statute. And the court tells us that the answer here is no. Right? Why does Young not apply when the federal suit is against a state official for violating state law? And the court tells us, the court reminds us that Young itself is a fiction, and as the court calls it here, it's an irony. The court says it's a well-recognized irony. And so the court seems to want to limit the reach of Young. And the court explains that the Young exception exists really to resolve this tension between state sovereign immunity and federal supremacy. Because if you think about state sovereign immunity, it could potentially insulate the state against a number of constitutional violations. when you say that the state is immune, that means that the state could violate the federal constitution or violate federal laws and essentially get away with it. The federal court can't hear the case. And there have been some pretty stark examples of this. A state violates someone's copyright, and the state cannot be sued in federal court for that. And so the victim is really at a loss. So we have state sovereign immunity, we have the issue of federal supremacy, because of course federal law, copyright law, is supreme to any state law. So how do we reconcile that? And in Pennhurst, the court says that, well, Young is a fiction, but Young was developed in an attempt to reconcile these two competing principles, that states are sovereign and therefore their immunity should be recognized in federal court. At the same time, federal law is supreme to state law. Those seem to be two principles that are in tension, and the workaround is this Young fiction. But what the court emphasizes here is that it is a fiction and it should be kept within some bounds. Right? So the court tells us that, so let's look at page 436. If you look at page 436, part 2, you see a background discussion. So essentially what the court does here is, in part 2A, it gives us some background principles. It goes through what the 11th Amendment does. So let's look at that for just a moment. Page 437. The court says that the 11th Amendment's greater significance. So it's clear, everyone agrees that the 11th Amendment was designed to overrule this 1793 case. But the court says here, its greater significance lies in its affirmation that the fundamental principle of sovereign immunity limits the grant of judicial authority. Right. Later in that paragraph, in short, the principle of sovereign immunity is a constitutional limitation on the federal judicial power. And then they quote this 1921 case, Ex parte New York. And let's look at that, because it really, I think, explains well how the court, especially the modern court, especially the modern 5-4 court. So as I mentioned, these cases today come out 5-4. Usually it's the 5 conservative members saying that the 11th Amendment prohibits the suit. Usually the 4 liberal members say that this whole concept of sovereign immunity is misguided. So let's look at that indented portion. That a state may not be sued without its consent is a fundamental rule of jurisprudence, having so important a bearing upon the construction of the Constitution of the United States that it has become established by repeated decisions of this court that the entire judicial power granted by the Constitution does not embrace authority to entertain a suit brought by private parties against a state without consent given. Not one brought by citizens of another state or by citizens or subjects of a foreign state because of the 11th Amendment, and not even one brought by its own citizens because of the fundamental rule of which the amendment is but an exemplification. Right? So let's look at that again, because this is as clear as it can be that by now, so this case is from 84. So by 1984, and certainly it's still the case today, that what the court is doing is it's not enforcing the text of the 11th Amendment. It's enforcing this idea. And what it so as the court says there in that indented quotation, the fundamental rule, and where do we get this fundamental rule from? It's become established by repeated decisions of this court. So it's clear that this is a court-created rule. Right? The 11th Amendment only applies to prevent out-of-state citizens from suing their own state, and as the court explains, the Hans opinion, because not even one brought by its own citizens, because of the fundamental rule of which the amendment is but an exemplification. Right? The rule of which the amendment is but an exemplification. Right? So again, the rule is really just standing in for this bigger spirit of sovereign immunity, right? Or as Holmes might say, not only is there invisible radiation coming from the 10th Amendment, but especially from the 11th Amendment. Right? So the idea that an out-of-state citizen can't sue a state is really just, the court is saying here, really just an example of this larger concept of sovereign immunity, which the court finds necessary to enforce, even though there is no express textual provision granting states sovereign immunity. So then go over to page 438 and we get part 2b here of this background section where the court discusses its precedent, and it goes through this distinction between suits against states, agencies, or departments of the state and against state officials. So this is essentially the Young exception. So what are the arguments here? If we look on page 439, we see the two arguments of Halderman. So the underlying issue here was that the state was administering this state-run mental hospital. It's called a school and a hospital. As the court says, this is a home for the mentally retarded, and the claim is that it's being poorly administered in violation of a number of laws and constitutional provisions. Right? They don't have enough room. They're probably not taking care of the patients in there, and there are a number of different headings under which the individuals here are suing. But the one that the state court rested on, at least when the case reaches the Supreme Court, was a state ground. So let's look at the arguments that Halderman is making at the top of page 439. First, they contend that under the doctrine of Edelman versus Jordan, the suit is not against the state because the courts below ordered prospective injunctive relief only. So this doesn't violate the rule of Edelman because no back money was awarded here. In fact, it looks on its face like the part of Edelman that the court approved, which was the prospective injunctive relief telling the Illinois officials to administer the program properly in the future, going forward. Here, the argument of Halderman is that's all this order did as well. It ordered officials to, in the future, not stop violating the state law. So that's argument one. Second, they assert that the state law claim properly was decided under the doctrine of pendent jurisdiction. So the reason the federal court has this state law claim before it is because there were other federal claims, and as you know from civil procedure, you can have pendent jurisdiction where a state law claim gets added because it's concerned with the same basic set of facts that the federal claims are concerned with. All right, so the big part of the excerpt that we have here deals with this first argument. Isn't this just like Young? Isn't this just like the part of Edelman versus Jordan that the court upheld, which was prospective injunctive relief? And the court, so let's look at that, at how the court addresses that first argument. The court says, of the lower courts, that they assume that those principles of Edelman and Young apply, even though this violation was a state law violation. Bottom of page 439, Edelman's distinction between prospective and retroactive relief fulfills the underlying purpose of Young while at the same time preserving an important degree the constitutional immunity of the states. Then the court says at the top of page 440, this need to reconcile competing interests is wholly absent, however, when a plaintiff alleges that a state official has violated state law. In such a case, the entire basis for the doctrine of Young and Edelman disappears. We conclude that Young and Edelman are inapplicable in a suit against state officials on the basis of state law. So this last point here, that Young exists primarily to resolve this tension between respecting the sovereignty of states and respecting the supremacy of federal law. Right? We need to invent this fiction in order to make sure that states don't get away with too much. But here the court says that tension is completely absent when the only claim for the suit against, where the relief is based upon an officer's violation of state law, right? Because then the court says there's nothing to balance. There's no tension to resolve, and instead the notion of state sovereign immunity is violated here, because what you ultimately have is a federal court telling a state officer that he misapplied state law and that he needs to better do his job applying state law in the future. And the court says that that won't serve as a basis for a way around 11th Amendment immunity. Okay. Then let's look at the dissenting opinion here, because I think it helps to clarify and refine some of the majority's opinion. So, the dissenting opinion of Justice Stevens starts out with this first point. And it's a dispute over the origins of Young and what Young stands for. So the majority thinks that Young is a fiction that is simply there trying to resolve this tension between state sovereignty and federal supremacy. But Justice Stevens says that that misconceives where Young came from, at least doctrinally. Stevens says that Young originates in the English common law, that in England it was well recognized that officers could be sued, even though the king couldn't be sued in name. Officers, the king's officers, could be sued for misapplying the law. And therefore, this exception, this officer suit exception, really has nothing to do with federalism, with trying to resolve that tension between state and federal authority, because we see this exception to sovereign immunity appearing in English common law. Right? So Stevens' disagreement here is pretty fundamental. It's about where this exception, this officer suit exception, comes from. And then more practically or more functionally, Justice Stevens says, if we're really concerned about state sovereignty or state dignity or states' rights, the majority actually gets it backwards. Right? If it's state law, you would think that if the state, as a sovereign, wants its officers to comply with any sort of law, it would be state law that would be at the top of their list, right? So this isn't the federal court imposing federal standards on state officers. This is merely the federal court recognizing that a state officer violated state law, right? And when the court wants to dismiss for lack of jurisdiction, what the court is essentially doing, the federal court, is ignoring the enforcement of state law. Right? So Justice Stevens says the best way to respect the sovereignty of a state is to enforce that state's law. But instead, he says the federal court ignores it. And he says if for some reason, if maybe the concern here is that the federal court would get the state law wrong, then the state can always avoid the remedy by simply changing the state law. And why does that make sense? Well, think again, what is Young limited to? Young is limited to prospective injunctive relief, so relief that's going to happen in the future. If you don't want your officer to be bound by whatever injunction the federal court issues, then simply change the law, and there would be nothing for him to do in the future, because the law would be different than what the injunction envisioned it to be, and it would simply become a dead letter then, the injunction that is. So Justice Stevens has a very different view then of two important aspects of the majority opinion: the purposes and the origins of the Young exception to sovereign immunity, and then practically speaking, how this cuts, how the ability to issue an injunction in a case like this, how this cuts in favor or against state dignity, states' rights. All right, so I think I'm going to end it there. Again, I recognize that this is a somewhat difficult topic. Do your best with it. Please don't hesitate to send me questions that I can then discuss during the Wednesday Zoom session. I'm also happy to respond to posts on the Twen page on the forums section. But again, just to wrap up and summarize, so new topic here, looking at the federal court's jurisdiction over suits against states. The 11th Amendment has been held to prohibit suits against states by private parties. One important exception to that is these officer suits under Ex parte Young, but as the court tells us in both Edelman and in Pennhurst, The officer suit exception has itself a couple of exceptions. The Edelman exception is no retroactive monetary relief against the officer when that is tantamount to um, um, a remedy against the state itself, and two, no prospective injunctive relief if the basis of the relief is a violation of state law as opposed to federal law. All right, the next class we will be looking at instances where Congress has waived or attempted to waive the state's immunity, or to use some of the more technical language, where Congress has abrogated the state's immunity. And we're going to look at instances where that's allowed and where the court says Congress is not allowed to abrogate that immunity.